this is very unique to have the Supreme Court just on Friday announced that they are going to have oral arguments in the Texas 6-week abortion ban that is the private right of action that is it's not enforced by the state next Monday, November 1st. And then December 1st, which we already knew about, is the case out of Mississippi, which is the heartbeat case, 15-week abortion ban. So we've got a month where there's going to be so much attention, but also attention by the justices. They're going to not have one, but two different bites at the apple of Roe versus Wade.
30, 40 years of back and forth, but really not a whole lot of movement in terms of, there's been a lot of movement on science and technology, and a lot of hearts and minds have been changed. But legally, this is really the first time in a very long time there's been something substantial.
A 5-week period of time where it's going to be fresh on those justices' minds. It's not one case, but twice, both cases, which I think is huge, by the way. Both cases are challenging the constitutionality of Roe versus Wade and whether or not the court got their reasoning wrong, which, by the way, as you know, Andy, people on the left who support abortion have said for years that the actual reasoning behind the case was inaccurate.
The question, I think, that ultimately is going to be decided one way or the other, whether it comes out of the Mississippi case or whether it comes out of the Texas case, I think in the crosshairs of the Supreme Court is going to be the continued viability of Roe versus Wade that was decided in 1973.
On one level, the issue will be jurisdictional. Do the plaintiffs, the abortion providers, have standing, for instance, to challenge the Texas law? With the Dobbs case, the Mississippi case, the key question is the core question, which is a merits decision on the viability of Roe v. Wade and Planned Parenthood v. Casey.
We are engaged in both of those cases. We are supporting, with the Texas case, we are filing an amicus brief supporting Texas, stating that federal courts are courts of limited jurisdiction and pointing out that these cases are not properly before the Supreme Court to decide at this time.
In this case, uniquely, there's a big procedural question about whether the court should even be hearing this case. And the Supreme Court takes those questions very seriously. A lot of their cases get decided on procedural grounds.
Federal courts lack jurisdiction to hear pre-enforcement challenges to privately enforceable laws. So keep in mind, in the Texas case, the law is enforceable by private plaintiffs. It's not enforceable by the state. It's not enforceable by a prosecutor. And so what the plaintiffs are doing here, that is basically the abortion providers, they're claiming the right to bring a lawsuit on behalf of women, let's say, third-party beneficiaries of the litigation in Texas before any abortions have been blocked.
What's the ACLJ doing? Well, Friday, the Supreme Court set a very quick deadline for briefing. We have until Wednesday to file our brief. We will be doing that as the American Center for Law and Justice, so you will be represented in this Texas case. It is an urgently scheduled case. It is not following the normal path. Because again, it was back forth. Remember, a couple times that law in Texas has been upheld, and you had the abortion industry try to file against it. Then you had the Department of Justice come in. When the Department of Justice came in, everything shifted.
The Supreme Court has stated that states have a compelling interest in protecting a baby's life. What's really the question is when that interest become compelling? Is it at a heartbeat? Is that at conception? Is that at 15 weeks? And that's the issue I think that the court is going to have to address. But it's an issue that should be something that the states get to decide when they get to protect a baby's life.
The unborn do have the right to protection under the Constitution just as much as those who are born and standing outside the womb. Why should we not give them those rights and see that they have their constitutional rights protected as well? Let's just say what the abortion industry is. In point of fact, the abortion industry as it has evolved and developed in the United States today is an industry of death.
The time for right now is to get ready for the battle, get the briefing ready, and now know you're not going to have one, but two, starting on Monday, just a week from today, to major cases challenging Roe versus Wade on the merits at the U.S. Supreme Court.